All right, welcome back. I've got a treat for you today. So, for those of you who are new, hi, I'm Joe. I'm an attorney licensed to practice in the state of Utah. And today we have a dramatic reading. So, this is a piece of legal, well, it's a legal writing masterpiece. Let's put it that way. That I found on Reddit, the cesspit that Reddit is. Sometimes you find gold, and this was posted. I found it on the r/sovereign citizen. It was originally posted to r/lawyer talk by AJC Polcom, and it's titled there, I've concluded that no reply to this pro se's objection will be necessary. So let's click over. I've made it a little bigger in this tab, and this may turn into a bit of a rabbit hole. I'm only covering this filing today. It's 2 pages, but there's more. There's a lot more to cover. So we'll discuss that at the end. But they've got it appropriately blacked out. This is in the Connecticut Appellate Court, posted November 16th, 2023. So it's brand new. And it's titled Opposition to the Motion to Terminate Stay. I don't actually know anything about this case other than this filing. So I don't know what the motion to terminate stay is. I don't know what the case is about. But this is 4 paragraphs of pure gold. So let's go. The defendant, blank, appellant, in the above captioned matter, hereby objects to the request from the plaintiff, also blank, to lift the appellate stay in the present caused by the defendant's appeal based on the defendant's motions number 133, 136, 137, and 139. The defendant sets forth the following reasons. 1. All mortgage contracts are null and void due to their, wrong there, violation of the U.S. Constitution of 1776. On December 6th, 1865, the present 13th Amendment was unlawfully added to the U.S. Constitution. It should have been the 14th Amendment, but history was rewritten, and the original 13th Amendment was removed from the public record. The original 13th Amendment put teeth in a provision already in the Constitution, the prohibition against American citizens holding titles and honors. The Constitution prohibits it, but the 13th Amendment designated a penalty. This amendment was stricken from the records by lawyers in America so they could be awarded the title Esquire. This is illegal under the Constitution. And if the original 13th Amendment were in effect, all members of the bar or British accredited registry would lose their citizenship. The present 13th Amendment was illegally used to create the Act of 1871, which has been used to pilfer money out of the hands of the American people to foreign powers for the past 152 years. Paragraph 2. The first U.S. Constitution was penned in 1776 by the leaders of the newly independent states of the United States. On July 4, 1776, the people claimed their independence from Britain and democracy was born. For 95 years, the United States people were free and independent. That freedom ended in 1871 when the original Constitution for the United States of America was changed to the Constitution of the United States of Jesus Christ. So, changed from Constitution for the United States of America to simply the Constitution of the United States. That's specific facts. Paragraph 3. The defendant, blank, operates in a top secret, autonomous military program designed to dissolve the Act of 1871 in U.S. bankruptcy court. Case number 20-40375. I am protected under the SEC Whistleblower Protection Program. Tip number 16449746. Paragraph 4. SEC Whistleblower Tip 16449746 proved that the 41st President, George Herbert Walker Bush, and the 43rd President, George Walker Bush of the United States, were bloodline relatives of Walter Scherff, who was appointed to the high command of the Nazi armed forces in 1942 by Adolf Hitler. This tip proved the American government was operating with a foreign government. They infiltrated America through the CIA and stole $2.3 trillion from the American people during their involvement in the September 11th attacks in 2001 on the World Trade Center. Legal grounds, paragraph 5. The Bar Association has violated Executive Order 13848 by acting as an agent with a foreign government to steal the 2020 presidential election to prevent any SEC whistleblower reports from becoming public knowledge. Therefore, all U.S. debt is invalid. Mortgage contracts are considered null and void. This requires all lawyers and judges to be retrained in constitutional law. A new constitutional practice book needs to be followed, as the current one is not in compliance with the sovereign policy of the Republic. Sixth and final paragraph. I kindly ask this court to overturn the lower court's decision or transfer this case to the U.S. Supreme Court for the correct constitutional ruling in accordance with the U.S. Constitution of 1776. Signed by the defendant. Bravo, defendant. Bravo. That was pure gold. Pure gold. And I mean, I don't need to give much commentary because it's pure and utter nonsense. First of all, the Constitution is not from 1776. It was ratified, I believe, in 1787, maybe 1788. I'm going off the top of my head. The Articles of Confederation weren't even in effect in 1776. The Declaration of Independence was signed on July 2nd, 1776, but that's not a governing document. It holds no actual power in the running of the United States. SEC whistleblowers, there's a reason that they are confidential. I mean, the whistleblower themselves, they can come forward, but the reason SEC whistleblowers are confidential is because it's dangerous. It's dangerous blowing the whistle on companies. I mean, they can be little companies. They can be people selling unregistered securities, they can be multinational Fortune 500 companies. In fact, there are provisions that there are mandatory reporters within these companies. The if they see securities laws violations, they're mandated to report to the SEC. So they need protection. Of course, if they blow the whistle and it turns out to be correct and the SEC gets a valid judgment and collects on the judgment, the whistleblower can become very rich because the SEC whistleblower program, the whistleblower can collect like 30% of what the SEC does. So we're talking, that there could potentially be hundreds of millions of dollars at stake for the whistleblower. But yeah, and this whole the because the Bushes are direct bloodline relatives of a Nazi, guess what? So am I. Well, I I mean, I've said before, my Oma grew up in Germany during the war. She was a teenager. I I don't I don't think her parents were party members. They weren't political, basically. They thought it was ridiculous. But, my great uncle, he was a teenage soldier. He was killed as a teenage soldier drafted by the Nazis. It's bad stuff. But the point is, having foreign relatives, even foreign relatives in government, that doesn't make you a collaborator. That doesn't prove you're operating with a foreign government. But guess what? You can operate with a foreign government. The US government can operate with foreign governments. That's what treaties are for. I mean, if the Bushes were independently operating with the foreign government, they'd probably have to register under the Foreign Agent Act, whatever, the stuff that Michael Flynn got. Did he get? I think he got in trouble for them. Paul Manafort definitely did. Either way, just doing business with a foreign government, not illegal as long as you do it right. Mortgage contracts. He talks about mortgage contracts are null and void because United States debt is null and void. Your mortgage contract is not a United States debt. It's not a debt of the US, it's your debt. So I'm guessing this might actually be a foreclosure action. This whole 13th Amendment stuff is nonsense. And I don't know if he's trying to claim that, hey, slavery's legal because 13th Amendment, or it's just everything needs to be renumbered and bumped one down to add this. But it's nonsense. And the 1871 Act, that's sovereign citizen gobbledygook. It's ridiculous. But yeah, so that's about all I need to say about that. But the rabbit hole I mentioned earlier comes from paragraph 3, and it's the U.S. Bankruptcy Court case number 20-40375. I believe that's in the Northern District of Florida Bankruptcy Court. So there's an action there against it's an involuntary bankruptcy commenced against the United States corporation. Let let's pull that up. Court listener. Let's see. $403.75. Let's just select jurisdictions to make it go faster. Okay, so it's this one, United States Corporation Company, In re United States Corporation Company. I'm just gonna say, you guys know I'm a cheapskate. I don't like spending money on Pacer. There's enough already on the court listener recap archive to make at least one video. But if you guys scroll through the docket and you see something that isn't showing up on recap that you think maybe I ought to do, if it suddenly shows up on recap as free, I might include that in the video, just hint, hint. But if not, that's fine, because there's plenty in here for at least one, and it's gold, pure gold. So with that, I'm going to leave you here with this one. We'll be back soon, maybe for this one, In re United States Corporation Company. We might save this for middle of next week, though, and do something else next. But either way, we'll do this one soon. So thanks for joining me. I hope you enjoyed this one as much as I did. I laughed my ass off the first time. So please like, share, subscribe, do all that fun stuff, and I will see you soon. Bye-bye.